Davion Workman, attorney, Mr. Alfred Fargione.
Good morning, Your Honor.
Morning, sir. Did I butcher your last name?
But you did well enough, Your Honor.
Oh, okay. That's a plus in this morning. Then.
Your Honor.
Yeah.
we Filed a motion to lift the bench warrant. Ms. Falk had sent us.
You probably need to come around and to the microphone. I'm sorry, don't use the double doors.
Your Honor, she,
Just 1 second. Okay, let me get to my Orca calendar. State code Orca, Orca A. Section 8. Okay, yes, sir.
Yes, Your Honor, we had filed a motion to lift the bench warrant. But during the course of the week, the solicitor's office had offered us a plea negotiation. We've accepted that, Your Honor. Unfortunately, my client was picked up on the bench warrant yesterday. He was released from Fulton County Jail around 4 a.m. And he told me that he was about 10 minutes away, Your Honor.
He's on his way?
He's on his way, Your Honor.
Okay, perfect. Thank you.
Yes. And
So we wait for him.
Yes, there's
All right. And he's already filled out the paperwork?
yes, Your Honor, when he was in jail yesterday, I just wanted to make sure that it got filled out just in case he had to appear remotely.
Okay. And let me go ahead. Miss, who's the prosecutor in this case for Davion Workman? Oh, Miss Paul, Miss Waldrop. Okay. Are you ready to proceed?
Once my client gets here, Your Honor, yes,
That was not your client. No, that's not you. Okay. As soon as he gets here, we're ready to go.
yes, Your
All
Honor.
right, thank you.
Thank you, ma'am.
On Orca C, motions calendar, Javon Bryant.
Good morning, Judge. That's my case. However, we have a mix-up. Actually, Javon Bryant's case should not have been placed on this calendar because I did not file a motion on his behalf. This case was a part of the conglomerate of cases that I was representing passengers from a roadblock that was set up April the 11th, 2021.
Mhm.
Mr. Bryant was a passenger, so his argument, of course, was a little bit different from the passengers, and we resolved the passengers' cases yesterday. But I think in me gathering the cases together, this case was inadvertently placed on the motions calendar when it actually should be placed on a final plea calendar. But he is here, he just came in. So if I could have a few moments to talk to him, we might be able to resolve it.
All right, do you know what the plea offer is?
I just received it this morning, so
Okay.
I just need to speak with him.
Okay, so go ahead and speak to Mr. Bryant and we will hold for your announcement.
Okay.
The next one I have is, of course, Mr. Toe, who represents Madison Chris. How far, what's the announcement?
Yes, Your Honor. I put her at home and she said she would be able to get on for 10 minutes.
Okay, excellent. So we'll hold for 10 minutes for. All right, do I have any other calendars for 9 o'clock? We have an officer here. For which case? Madison Chris, okay.
Your Honor, if I may, while we're waiting, I know I'm jumping ahead a little bit. You have a 1:30 bench trial calendar.
Yeah.
I understand that we have a resolution in the position number 1. If that's all right, they're going to make that announcement in that case.
Amber Addington
Yes.
and Miss Waldrop, is that your case?
That is Judge, that is correct. I did keep your health costs on that case as well as the other case.
Oh, okay. So Amber Addington, position number 1, all charges are null crossed.
Yes, Your Honor.
Position number 2, Ernest Wiggles, all cases, all charges are null crossed.
That is correct, Judge.
So the bench trial calendar is concluded. Mr. Gaither, normally I wait till Christmas for a gift like that, but thank you.
Suspended. Suspended or suspended.
All right. Yeah, happy Valentine's Day.
So you can plead to the license suspended.
That's what they have down. Let me go.
All right, while I'm waiting for Miss Chris to appear, would the host please let us know as soon as she appears in the waiting room? Mr. Rockoff, do you have a case with us? Are you on mute, sir?
I have no cases. I'm out of here.
All right, you have a great weekend. Thank you.
You too, Judge.
All right, Miss Cripps is present. But Mr. Toe, if the podium right there. Yeah, I'm sorry, don't use those double doors. They're rather, all right, we have Madison Chris, who is present via Zoom.
Yes, Your Honor, I'm here.
Okay, great. All right, so this is the case of State versus Madison Chris, 20 CR 003-437Y. Ms. Crisp is accused of driving under the influence of alcohol, less safe, reckless driving, failure to maintain lane or improper lane change from August 29, 2019. She's appearing by Zoom. Ms. Crisp, I'd like to remind you that you have a right to remain silent about the fact of the case. Anything that you choose to say during the course of this Zoom proceeding, your statements can and will be used against you. Mr. Toe, if you can position yourself as close as possible to that microphone right there.
Yeah, I turned it, waiting.
All right, excellent. Thank you.
Honor.
All right, and Ms. Crisp is represented by Mr. Travis Toe. All right. The motion for waiver of appearance is dismissed as moot. Ms. Crisp is present. So the only outstanding motions, Mr. Toe, are?
Yeah, we have motions to suppress, Your Honor. The issues to go over would be the no probable cause for DUI investigation, no probable cause for the arrest, implied consent, and of course, the Elliott case.
All right. Where do we plan, and the state has a witness?
Your Honor, Officer Bird of the Kingsman Police Department.
All right. Now, considering the interesting layout of this room, Ms. Waldrop and Mr. Toe, where would be the best place to position Officer Bird? I can have a chair right here in the clerk's office, right in front of the clerk, and he'll be seated there, and you can direct and cross him, and the court reporter will be able to take down all the information. Would that be satisfactory?
Yes, Your Honor, that's fine. I will say the last time I did do a motion in here, which was the first time, this witness sit over there on the bench, but wherever.
Oh, okay, that's fine too. You want him seated in the gallery at the
Well,
bench?
There will be a video play, Your Honor. State does have a video to.
Okay. Officer Bird, I do apologize, but given the interesting layout of these rooms, the Zoom infrastructure, you're going to be seated in a rather unorthodox location.
And Your Honor, before we get started, Attorney Toe and I did,
Right, here's one.
potentially stipulate to identification. Given that.
Okay, let's go ahead and put that stipulation. What is the stipulation, Ms. Waldrop? You need to be in front of a mic. That one or whichever one you want to use. It's on.
Yes, Judge. Defense and the prosecution did agree to stipulate to identification for purposes of the motion.
All right. Okay, we are going to address the defendant's motion to suppress the information. Let me see. Are you okay? We good? All right, like I said, it's rather unorthodox, but we make do with the best that we have. All right, you may proceed. Officer Bird, if you want to stand up. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, and could you please state your full name and your agency you're with?
My name is Patrick David Burt. I work for Sandy Springs Police Department.
And how do you spell your last name?
Burt is B-U-R-T.
B-U-R-T. Thank you. All right. You may proceed, Ms. Walter.
Okay, Judge, just give me 1 second to cue up the video.
And we've stipulated the identity of the defendant, so for the record, Madison Crisp is the individual involved in this case and the individual with whom Officer Burt, well, I don't know whether he personally had any engagement with her, but she is the defendant who was arrested for the charges in this case, correct, Mr. Toth?
Yes, Your Honor.
All right, correct, Ms. Walter?
Yes, Judge. And I've got it plugged into the TV, but it's not showing up, so.
If it's not coming that way, do you want to log into Zoom from there and then we can ask the host to give you sharing privileges? Don't
Okay.
worry about it that way.
Sure, we can try it that way. Yes, let me see if I can do that.
Who am I sharing privileges with?
As soon as she logs in, Ms. Waldrop is going to log in. And then you'll give her screen share rights.
Yes, ma'am.
Monica, are these null process with you?
Submission. Yeah, yeah.
Judge, I'm just trying to find a network to connect to.
Sometimes it's a little wonky.
Okay. So where are the networks?
Yeah, sometimes if we.
So when are we seeing him?
He's supposed to go on your main jury shot calendar. He's supposed to go on the main jury shot calendar.
Okay. Yep.
Too good for that issue about later.
Okay.
I don't know why it's not coming up. Is this a county laptop?
Mhm.
Hmm. You should have to connect remotely. You should be able to just go ahead.
Wait, I switched that over to the-
See that, I don't even mess with it. 'Cause that's a whole nother. Okay, here we go. Here's your email. So I can pull up the Zoom link.
Okay, I can put it up.
Okay.
Are we still trying to fix the video issue?
We are, Judge. I'm just pulling up my email so that I can receive the Zoom link.
Oh, okay.
It still say for some reason it's not connected. That's so strange. Okay, do this.
Mhm.
Is the video on a USB?
It's on a
or
DVD.
thumb? It's on a DVD.
Mhm. It's not showing up.
It may be playing, you may be on the wrong screen if you're using the wrong HDMI.
Yeah, that's what I was thinking.
Look at me, like I know what I'm talking about. See, that's it? Okay.
Is she logged into Zoom, Monica? For some reason, that computer is not attaching her to the Fulton County network in any way. So that's the problem.
I think so, yeah.
You should be using a laptop.
I'm gonna say it's another way you can launch this. Okay. Ms. Walter, why don't you try to resolve your laptop issue? With maybe,
Where you look.
Then- and I think Mr.
It's another one she can log in.
Mr. Workman is here?
Yes, Your Honor.
Okay, we can pause on this motion. And there's the HDMI's right there.
See how you get it back to where you can see it.
Okay. Deputy, I'm going to start the plea hearing and that's not going to take too long. We good? That's fine. Just put a pause on that. Okay. You can, yes, please come around.
Hey, take your hands out the pocket, man. Thank you so much.
Unless you'd like to stay and listen to this motion hearing, then, you know, I'd be glad to.
Thank you, Your Honor. I appreciate it. Courtesy.
This was the motion.
Okay. This is State versus Davion Workman, case number 22 CR 007228. Mr. Workman is present in the courtroom with his counsel. Mr. Workman, you have the right to remain silent about the facts of the case. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney and you're represented by Mr. Alfred Farchione.
That's right, Your Honor.
Okay. Mr. Workman was accused of driving a circular or zigzag course lane drag. A prior court appearance was scheduled whereby the defendant failed to appear and a bench warrant was issued. It appears that the bench warrant was executed.
It was
And
yesterday.
Mr. Workman has bonded out on the bench warrant, correct?
Yes, Your Honor.
So in light of that, the motion to set aside the bench warrant is dismissed as moot.
Yes, Your Honor.
Okay. Moving on, the state and defense have reached an agreement and a negotiated plea has been accepted. So we're going to proceed with a negotiated plea.
Very good, Your Honor.
Purposes, thank you. For purposes of the plea, Mr. Workman, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. We're going to hear from the prosecutor as to what the recommended offer is, and then I will let your attorney say a. That's why we don't use that. Okay. Make a few comments, and then I'll be asking you a series of questions. All right?
Okay.
Okay. Ms. Waldrop?
If I may, Your Honor, can you please turn your phone on vibrate, but please, thank you so
Thank
much.
Yes, Judge, the defendant is pleading to one count of driving in circular or zigzag course, also known as laying drags. The state's recommendation in the negotiated plea is 12 months probated for the defendant to pay a $500 fine plus any court costs. The sentence is to be suspended upon the fine being paid in full. Counsel, do you stipulate to a factual basis?
We'll stipulate to a factual basis, Your Honor.
And Your Honor, this is a negotiated plea.
Stipulate your venue and ID as well?
We do, Your Honor.
1 second, please. How much did you pay on the bond?
It was $410. It was $300, but after the jail fees and the taxes, it was $410.
Okay. I'm going to, if this plea goes forward, I'm going to suspend the fine and close the case out.
Okay.
Is that acceptable, counsel? Or would you like him to be on probation?
No, Your Honor, that's perfectly acceptable.
Okay.
Thank you very much, Your Honor.
All right. Mr. Workman, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney? And have anyone forced you or induced you to take this offer?
No, ma'am.
And has your attorney explained to you that in accepting this offer, you would have to give up your constitutional right to go back to court, to have a trial in front of a judge or a jury, to have the assistance of counsel so that you could challenge the evidence presented by the state, examine witnesses, confront your accuser, present any defenses if you choose to do so, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead to one count of driving for in circular or zigzag course, otherwise popularly known as lane drag?
Guilty.
Your sentence is 12 months to 12 months probation to pay a $500 fine. I'm going to suspend the fine and the case is closed. There's no probation. Thank you.
Thank you, ma'am.
Thank
Anything
you.
else?
No, Your Honor. may I be
All right.
excused?
Thank you. Yes. Thank you for coming out in this rain. I appreciate
Yes,
it.
ma'am.
Y'all be safe. Thank you. All right, Ms. Waldrop, we're going to resume with the case of Madison Crisp. And as soon as all the technical issues have been resolved, right, Officer Burt has been sworn
Yes.
and touching wood, no more hiccups. Let's go.
Yes, Judge, and the state is ready to proceed. Thank you, Your Honor, for your patience. And Officer Burt, please just once again introduce yourself to the court.
Officer Burt, Patrick David Burt, badge number 284. I work for the Sandy Springs Police Department.
Okay. And how long have you been employed as a police officer?
I've been employed as a police officer for about 9 years.
Okay. And are you post-certified?
I am, yes.
And were you post-certified on the date of August 29th of 2019?
Yes.
Can you tell the court about your law enforcement training and experience, please?
Currently on the traffic unit, we investigate fatalities, speed detection, and also DUIs.
Okay. And in your 9 years at Sandy Springs Police Department, how long have you been doing those things?
Going on off and on for now 3 years.
Okay. And I heard you say you do traffic enforcement, including DUI. Can you tell the court about your specialized DUI training?
I'm since November of 2018. That's when I took my standardized skills sobriety test with HDN, horizontal nystagmus
Okay,
with the eyes.
okay. And have you had any other training?
Not in DUI.
Okay. And that is a field sobriety evaluation, correct?
Yes, ma'am.
Okay. And were you employed with the Sandy Springs Police Department on August 29th of 2019?
Yes, ma'am.
Okay. And about what time do you recall being on duty?
My shift would have been from 6 p.m. to 6 a.m.
Okay. And on that particular day, were you in uniform to include your badge?
Yes, ma'am.
And were you in a marked police vehicle?
Yes, ma'am.
Did you have the opportunity to encounter the defendant, Miss Madison Crisp?
Yes, ma'am.
Okay. Can you tell the court what first drew your attention to Miss Crisp?
The speed of the car that I saw, and then the weaving, and the actually did a construction barrel.
Could you repeat the last phrase, please?
Saw the construction barrel that was on the side of the road, and when she did that, she jerked from the far right lane to the far left lane.
And you said she jerked from the far.
Far right lane to the far left lane.
Okay.
One close from the right shoulder to the inside leg.
Okay. And I heard you say that as part of your duties at the Sandy Springs Police Department, you do detection of speed. Is that correct?
Yes, ma'am. I'm also power certified. Right lane.
And during the time that you have been driving as a Sandy Springs police officer, have you observed other motor vehicles in motion?
Yes, ma'am.
Okay. And based on your training and your experience, can you fairly judge or estimate the speed of a motor vehicle by observing it in motion?
Yes, ma'am.
When you first noticed the defendant's vehicle, did you form an opinion or estimate as to its speed based on your observations?
Yes, after the jerky motion, I proceeded to try to catch up to the vehicle. It was going at a high rate of speed.
Okay. And what was your opinion as it relates to speed?
I knew it had to be well over the excess of the speed limit at the time on where she was.
Okay. And do you recall implementing what is known as pacing?
Yes, ma'am.
Okay. And what did that tell you with regard to the speed that she was going?
It told me that she was going approximately 120 miles an hour.
Okay. And explain pacing for the court, please.
Pacing is where in my certified police vehicle has a certified speedometer. I will pace the vehicle at a known distance, not a known distance, but an unknown distance, just unmatched speed with her. And once my speed matches her speed, I can get a accurate description of how fast she's going.
Okay. And what was the posted speed limit at that location?
The posted speed limit at that time was 55 in the construction zone.
Okay. And that particular roadway, do you remember what it's called?
Ma'am, I can repeat the question.
That particular roadway, do you remember what the name of the road was?
Yes, it's through the 400.
Okay. And is that a public roadway in the city of Sandy Springs?
Yes.
Okay. And in what county did this occur?
Fulton County.
Okay. And did you stop the vehicle that you observed traveling that you paced at a speed of 120 miles per hour?
Yes, ma'am.
Okay. And before you relay your encounter with the defendant, I do want to ask you just a couple of questions about your police car and your uniform. Was your patrol vehicle at that time equipped with a camera?
Yes.
Okay. What about your uniform? Was that equipped with a body camera?
Yes.
Okay. Do you know what type of equipment was installed?
The in-car and dash camera been an Axon camera, and my body camera been an Axon camera as well.
Okay. And is it routine for Sandy Springs patrol cars and uniforms to be equipped with a camera?
Yes, every time we are out with the public.
Okay. And how do those operate?
My in-car dash camera will operate when I turn on the blue lights, or I physically turn it on, and my camera on my body when I activate it with the button on the front.
Okay, so the body cam is manually activated?
Yes.
And with regard to that body cam, what angle specifically does it record? Is it a head-on direct view?
Yes, it's facing forward.
Okay. And did your body cam appear to be working normally on the day in question, August 29, 2019?
Yes, ma'am.
Okay. And when did you last view that tape?
This back week.
Okay. I'm going to play a portion of the video and just ask you a couple of quick questions.
Is he still here?
Yeah, he's sitting right.
Miss Walter, someone from IT is here. Do you need any further assistance?
Thank you.
We felt those for you guys.
Is your audio on?
It is.
We may want to check the audio.
Gail, come on in a second.
Yeah, a few seconds. That's all. Where do you want to go?
Okay, is this the tape that has your encounter with the defendant recorded?
Yes, ma'am.
Okay. And is that how you recognize this tape?
Yes, ma'am.
Okay.
That's definitely my voice.
Okay. And is this a fair and accurate depiction of your encounter with the defendant?
Yes, ma'am.
To your knowledge, have there been any material additions, deletions, or alterations to this?
Not to my knowledge, no.
Your Honor, the state would ask to tender into evidence State's Exhibit 1, which is the video of Officer Burt's encounter with the defendant.
No objection.
All right. Plaintiff's Exhibit 1 is admitted, and just for the court's clarification, this is the video from the car cam,
This is a video from body cam, Your Honor.
body cam.
Yes,
Okay.
Judge. Permission to publish?
Yes, you may.
Thank you.
Where's work at? What? How much you have direct on? How much is not much? Okay, so I paced you at 120 miles an hour. Yes, what?
No, I believe you, but
I need to step out of the car. When's the last time you had a drink? About 30 minutes ago, would you have? Okay. Where's this, damage in the front of your car from?
that's from Florida.
That's from Florida?
Yes,
Right.
sir.
Where's your license at?
From
Yeah, you guys. Got glasses on you?
Yes, sir.
That's fine.
Yes, sir.
Where's that?
It's in my,
We'll get it back. Sit back here for me. Just take it back in your car. All right, so what's the deal? Why are you going so fast? Where's home at?
yes, sir.
Where's that at?
Barbie.
Fighting. Where's fighting?
Yes, sir.
Okay. That's, down. 15, 20 minutes, that's right. Okay, you said you work at a bar,
It's, it's just the cafe.
cafe, and where? Where's that at?
It's definitely.
So you work at Youngwood and going home, you're just tired, so that's why you're going about 120 miles an hour.
Well, I,
Alright, well, I'm basically like I said, about 120 miles. Okay. You got a beer about 30 minutes ago. Okay, do you want us to mention any kind of deal price set? You don't want to? Alright, so you're gonna refuse. Alright, go around. Go around. You're being placed under arrest. Correct, driving suspicion of DUI, okay? Where do you want to check out, one trustee?
Submit.
Pardon, ma'am, so I can't let you, you refuse, so we're gonna go back, pull back here for fun. Just stay right here for me. You got anybody come to your car?
My mom.
Where's, how far is she away? Alright, you got anything on you?
Yes, sir.
I'm just gonna
Yes, sir.
back it down. Alright. I'm trying to, you got anything in your pockets? See anything here, don't see anything here. You have a blonde one or no? Yeah, okay, I'm about to check that. Alright, you can set my car for me. Where's your phone at?
I'm in my car.
Thanks, okay? What's going on, Melbourne?
Yeah, 404.
Is it under mine?
It's under mommy. Computer, yeah,
What is in front of you? Okay,
yes.
alright, she gonna answer because it is. Pretty fun.
Yeah.
We talked to you today. So we don't speak to us. Just don't say anything.
Ask if we record this, not necessarily post arrest.
Your Honor, it's not a long video.
You can
Um,
pause.
Yes, Judge. It's not a long video. I'm just getting to the implied consent and then I'll stop.
Okay. Yes.
All right, so withdraw objection,
Oh, yeah,
we'll
that's fine.
continue? Okay,
It's-
go ahead.
it's also a thing. I was just wanting to save time.
Hey, what's your name? Well, listen, I have your daughter here, Miss Red. Okay, so I'm just letting you know she's been placed under arrest with suspicion of DUI and reckless driving. Was wanting to know, did it come to your car or should we have it towed? I'm just gonna let her know she's heading to Colorado City Jail. She'll be able to wind down tonight, more than likely. So she'll be able to give you a call when she's ready to be picked up, okay? Yes, sir. Okay. Yeah, I thought I had these bills, but I don't. You gotta apply to see card. I gave it apply to somebody. How old are you? 21, when did you turn 21? July 18, 2019?
Yes, sir.
Alright, so. This is your first DUI? Okay, so I'm gonna read this up right. I'm gonna read this up, okay? I just need you to listen to me, okay? The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to state administered chemical tests of your blood, breath, urine, or other bodily substances for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you're entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and from qualified personnel at your office. The state of use of chemical testing for what? Thank you so much.
And you're gonna stop here.
I'm sorry, Ms. Waldrop, what'd you say?
I will stop there.
Okay. That is the conclusion of publishing States Exhibit 1. Okay,
Yes, Judge.
anything else?
Just questions for the officer, Judge.
All right, so please resume.
Thank you. Officer Burt, where was the defendant located when you first approached her vehicle?
She was in the driver's seat of their white Honda.
Okay, and at that time, how far would you say that you were from her distance was?
When I made initial contact, I mean, no more than a foot and a half.
Okay. And during your interaction with her, how far would you say that you were away from her?
Same, about a foot and a half.
Okay. And during your interaction, did you notice any odors about the defendant's person that you could identify?
Yes, she had a strong odor of alcohol beverage coming from her inside the vehicle and her breath.
Okay. And have you had the opportunity to smell the odor of alcohol in the performance of your duties as a police officer?
Yes, ma'am.
Okay, and so you're confident that that was the odor that was emanating from the defendant?
Yes, ma'am.
Okay. Did you notice any other manifestations regarding the defendant?
The slurred speech, the way she was talking, and also her eyes a little watery, and bloodshot.
Okay. Now, this was your first encounter with the defendant, correct?
Yes, ma'am.
Okay, so you indicated slurred speech, but you had never spoken with her before this particular day, correct? Okay, so with regard to speech, have you had the opportunity to hear individuals speak in a slurred manner?
Yes, ma'am.
Okay, and is it your opinion that her speech replicated that?
Yes, ma'am.
Okay. At some point, you asked her to exit the vehicle, correct?
Correct, yes.
And why did you do that?
Getting out of the vehicle with the smell of alcohol, I wanted to perform some sobriety test to make sure she was safe to travel on the roads.
Okay, and what were your observations regarding her? Well, first, it appeared from the video that you asked her to walk behind her car, is that correct?
Correct, yes.
And what were your observations about her?
She held onto the car with her left hand, and she also pushed on a little bit.
Okay. Okay. And was anyone else on the scene besides you and the defendant?
Officer Robert Morgan appeared once I had her placed under arrest.
Okay. And prior to arrest, did the defendant make any statements about whether she had been drinking? And what did she indicate?
She said she'd had a beer about an hour ago. 30 minutes, sorry.
Did you ask the defendant to perform field sobriety evaluations?
Yes, ma'am, I did.
What was her response?
She refused, said no.
Officer, how many times would you say that you had the opportunity to observe individuals in your capacity as a Sandy Springs police officer driving and under the influence of alcohol?
Several times. Out of a few DUIs that I've done over the years.
Okay, over the period of 9 years,
Yes.
can you roughly estimate for the court?
Roughly probably about 15.
Okay. And were the manifestations that you observed on August 29th with respect to the defendant consistent with someone who had been drinking alcohol?
Yes, ma'am.
And based on your experience and training and the manifestations that you just told the court about with regard to the defendant, did you have an opinion as to whether or not she was under the influence of alcohol to the extent that she was less safe to drive?
Yes, ma'am. That's why I placed her under arrest.
Okay, so your opinion was that she was less
She
safe
was-
to drive?
yes, ma'am. She was not in a state to drive.
And you placed her under arrest, correct?
Yes, ma'am.
Did you read her the Georgia implied consent warnings?
Yes, ma'am, I did.
And what section of that did you read?
It should be for 21 or over.
Okay, and how did you determine the defendant's age?
I determined, asked her and also checked with her driver's license.
Okay, at what point specifically did you read her the implied consent warnings?
After I placed her in handcuffs and she was securely in the back seat on patrol car.
So immediately after arrest?
Yes, ma'am.
Okay, I'm going to show you what has been marked as State's Exhibit 2.
Yes, Your Honor. I may object. I would like to ask whether this is his implied consent card or a copy of it.
All right, so I assume State's Exhibit 2 is a copy of the Georgia implied consent notice.
Correct.
All right.
Specifically his.
So what is the objection?
That the objection is this is not a copy of his card that he read. That he didn't even read his card. He doesn't have a copy of the implied consent card that he read to her. It was that he borrowed it from someone.
All right, Ms.
And Your Honor, I can flesh that out in the
Says-
foundation. I can flesh that out in the foundation.
All right, I'll reserve ruling on the admission of plaintiff's Exhibit 2.
Take a look at that.
Be the card that I read.
Okay, what is it that you just looked at?
The section where it says over 21 or over.
But in general, what is this document?
Oh, that's the Georgia implied consent law.
Okay, and do you recognize it?
Yes, ma'am.
How do you recognize it?
I reckon it's the same. It would be the card that I use for every DUI I've ever done.
Okay, and is it a copy of the card?
Yes,
that
it
you
is.
just-
That is copy.
Okay, is it an accurate copy of your Georgia implied consent warning card?
Yes.
And where is the original Georgia implied consent warning card kept?
It's usually in my pocket.
Okay, and is this copy, the implied consent warning card that was in effect at the time of the arrest and that you read to the defendant?
Yes,
Okay, did you read it verbatim to the defendant?
verbatim, yes.
Okay. Your Honor, at this time, state would request to tender into evidence State's Exhibit 2, which is the Georgia implied consent card. It is a copy of the officer's card that was read.
All
at the
right,
time.
so the objection is that even though the contents of State's Exhibit 2 may be a verbatim copy of the Georgia implied consent notice, the objection is that this Officer Byrd did not read it from this copy or didn't read it from this of his card, but read it from the other officer's card, as we just saw in State's Exhibit 1. All right, and that's the objection.
Understood, Your Honor, but we are allowed to tender a copy, and he did testify that this copy is what he read. It would be verbatim, the same exact thing that he read.
Understood, Ms. Waldrop. Mr. Toe's objection is that he didn't read it from his card. He didn't read it from a copy of his card. He read it from some other officer's card. That's the objection. Am I right, Mr.
You're
Cho?
right, you're correct,
Okay.
Your Honor.
So if you could please address that objection.
Your Honor, I just have a couple more questions.
Oh, we have to address the objection too, unless,
Well, Your Honor, with respect to his objection, it would go to weight and credibility, not admissibility. But I can flush it out a little bit more with the officer if you would like.
all right, we're going to reserve ruling until Ms. Waldrop, you go ahead.
And Officer Burt, is this card a copy of the Georgia implied consent notice that was in effect at the time?
Yes, there should be a version on the bottom of it, of what the date it was printed.
Okay, and is the card that you received from the other officer that we saw on scene, would that have also been the card that had the notice on it that was in effect at the time of this
It'd have been
particular
the
stop?
exact- It'd have been the exact same card.
Okay, and is this typically what it is that you would read after effectuating a DUI arrest?
Every time, yes.
Okay. Nothing further, Judge.
All right, so based on the officer's responses, do you have a rebuttal, Mr. Toh?
Yes, Your Honor, I do object under best evidence rule and the fact that he should have his card or a copy of his card, so I definitely object to this.
All right. I'm going to overrule the objection, but this, we have already heard testimony. We've already seen the state's exhibit 1, where the Officer Burt took the implied consent card from another officer, Officer Morgan, I believe. Okay. And the contents of Officer Morgan's card was read to the defendant as we saw on the video. And the defense may cross-examine the officer and the contents of what was read to the defendant to see whether the information relayed to the defendant at the time of the arrest deviates from the Georgia implied consent law. The law requires that the defendant be read the implied consent notice for the appropriate age. It doesn't designate that it has to be the officer's personal card, as long as the contents of the law is correctly conveyed. So, but that's a subject for cross-examination. Overruled. Next question.
Your Honor, I just tender into evidence the state's exhibit 2.
Admitted.
Specifically, what type of test did you request the defendant to perform?
Blood.
And what was the defendant's reply?
She said no, she refused.
Repeat, please.
She refused.
Okay.
Nothing further at this time, Judge.
Right. Mr. Toh, your witness for cross.
Thank you. Good morning, Officer Burt. How are you doing today?
I'm good, sir. How about yourself?
Doing fine, thank you. So you said you observed her, you were pacing her at 120 miles per hour, is that correct?
Yes, sir.
Okay, how long were you pacing her?
For approximately about 1.5 miles.
Okay, why did you not pull her over before the 1.5 miles?
There was constructions on the, there was barriers on the side of the roads. I was waiting for a safe spot to pull over
Okay,
to activate my emergency lights.
and when you stopped her and your reason for stopping her, I believe you said that was because she was speeding, is that correct?
Speeding and reckless driving.
In reckless driving, okay. It's not on the video where where she was allegedly swerving to the constructions, that's on the video, okay. Did you ask her why she had swerved?
I did not.
So you have no idea how she swerved? Why?
No,
She could have been on her phone or some animal on the road or something, just no idea.
right.
All right, now you had testified that, Ms. Chris had, slurred and specifically stumbled or when she was getting out of the car. Could you point that out and where she, stumbled or misstepped on the video?
It's not on the video.
It's not on the video. Okay. But we saw her presence the whole time on the video.
Yes, but not walking.
Okay, I guess that's for, when did she stumble then? What
She was
point?
walking from her driver's side door to the back of her car.
Could we watch the video again? Because I'm curious as to why. I
Waltrip, if you could bring,
can't see the,
At what point did you want to go back to?
I think it would have been earlier in the
Timestamp.
video, probably in the first probably after 60 seconds, if I recollect.
You're being placed under arrest.
Oh,
When last time you had a
Before
drink?
there we go.
Got lights on you?
Yes, sir.
That's fine.
Yes, sir.
Where's that?
It's in my car.
All right, we'll get it back. Sit back here for me.
so,
Just stand on the back of your car. All right, so what's the deal? Why you don't?
so where was she stumbling?
When she was walking from the, like I said, it's not on the video, it's my body camera facing forward.
Right, and your body cam faces forward, so that means you're likely facing forward too. So were you, I mean, did you see her do this?
Yes, I did.
With your head turned like this? So you had your head turned and you saw her?
Yes,
If that's your testimony, that's your testimony. It's I understand. Okay. So, you said that you, noticed alcohol, smell of breath, right? And she did admit to drinking, right?
yes,
One beer,
yes,
30 minutes before.
yes.
And you said that that she was slurring, is that correct? But you've never met her before, right?
No, not.
You also mentioned that she had bloodshot and watery eyes, is that correct?
Yes,
But you've never ever seen her eyes before.
no.
Are there any other reasons that could cause bloodshot, watery eyes besides, alcohol consumption?
Yes,
Such as working at a cafe?
I assume yes.
Yes, so, and it is summertime when this happened, right?
Yes,
Allergies is another possibility that would give her eye bloodshot.
Yes, sir.
Okay. And so when you were doing the, asking to get out of the car, you, wanted to start the DUI investigation, is that correct?
Yes.
To see if she was impaired to drive.
yes,
And she refused everything, right?
yes,
But you started the investigation to see if she was impaired to drive, just as you testified.
yes,
So she wasn't, you had not determined at that point before you asked her to do the field sobriety test, whether she was impaired or not.
I had suspicion that she was impaired.
A suspicion. Okay. Now, had you not asked her to do any of these exams, and she just got out of the car like she is right there, would you have arrested her for DUI?
No, I was probably arrested for reckless driving speed.
So the fact that she refused is why you arrested her for DUI.
Yes, because I had suspicion that she was drunk.
You just said that you would not have arrested her had you not asked her to perform the test and she had not said no. You said you would have arrested her for reckless driving. Is that correct?
Yes.
Okay, that's all your, no further questions, Your Honor.
Ms. Waldrop, do we have a redirect?
Yes.
You described what the construction zone looked like on 400 on that particular night.
Being cement barriers all the way down, starting at Marta to past Abercrombie. About the time that I caught up with her, that's where we would have been at.
Okay. And did you see any animals on or in the roadway of Georgia 400 that particular night?
No.
And was the watery bloodshot eyes the only manifestation or indicator of impairment that you saw on the defendant?
No, it was the slurred speech and the weaving of the vehicle as she was driving.
Okay, and was it also her walking?
Yes,
And was it also the odor of alcohol?
yes,
And is the odor of alcohol what indicated to you that the defendant had the watery bloodshot eyes, that was a result of that?
yes,
And was it also her admission to having had a beer 30 minutes prior to driving?
yes.
Just one moment, Judge.
All right.
Sir, I believe the defense asked you a question about would you have arrested her for DUI had she not refused? Can you just explain your response with regard to your arrest of the defendant for DUI? Explain your response to defense counsel, please.
So I was getting out of the car to do fields, try to do field to see if my suspicion of the alcoholic beverage I smelled and her medication on the road. Do fields, I was going to see if she was less safe to drive. When she refused the fields, she was placed on arrest for suspicion of DUI and also recognized.
Okay, but you did, at the time that you arrested her, believe her to be less safe
Yes,
because of the alcohol she admitted to consuming.
Yes,
Is that correct?
that was a big key.
Okay. Nothing further.
All right. May this witness be released? Oh, did you have a recross, Mr. Till?
No recross, Your Honor.
No recross. Ms. Waldrop, may I release Officer Burt? Officer Burt, thank you so much. You're free to go.
Thank you.
Or anything else from the state? All right. Mr. Till?
Yes, Your Honor. I believe that there was no reason to arrest for DUI. Suspicion. She was completely coherent when she got out of the car. We did not see any stumbling or and I did not personally, I did not hear any slurring on the video, which is, as the officer testified to, was very close to her, a foot and a half away. And at no point does she have any manifestations that are apparent on the video of a potential DUI arrest. And not only that, but I asked the officer if he would have arrested her for DUI had he not gone forward with a question on whether or not she would agree to the fields. Okay, had he not said that, if he said no, I would have arrested her for reckless driving. That is absolutely indicated that he did not have a suspicion of DUI at that point. He stated on the stand he would have arrested her for reckless driving had the last 5 seconds before he arrested her, if that conversation did not come up. So he was not knowledgeable that he did not believe that she had DUI at the time. He said it would have arrested her for reckless driving. So that's the point on that one. So I would like to raise, of course, the Elliott case that her refusal is not brought up in trial. And also that if there is a trial, that we redact part of the video where she refuses the implied consent.
We redact the video up to the point
Or she refuses because Elliott's-
before the implied consent is read.
Yes, sir.
Okay. Where Officer Burt asks his colleague to borrow his card and then to read the implied consent.
Yes.
Right before that point.
Yes, sir.
Okay, I just want to be sure.
Okay.
I want to make sure I'm, they'll revisit my ruling and get me. in
You can
trouble.
redact all of it to the point you pulled over if you like.
All right, understood, Mr. Toy. Anything else, sir?
No, Your Honor, I also would like to say that, and I've argued he had no probable cause to arrest for DUI. I'd also like to argue that he had no probable cause to arrest her at all for the reckless driving. It's not too unusual that people swerve every now and then for some unknown reason, but my argument that speeding is not one of the less safe acts that is in the National Highway Transportation Safety Administration. There's a list of 7 or 8, but speeding is not one of them. So that cannot be considered a less safe act. Therefore, it's not a reckless driving situation. And the fact that she just swerved does not rise to the level of being arrested for reckless driving. She should have given her a citation for failure to maintain lane.
I believe he did.
Yeah, instead of arresting her for reckless driving, which I'm arguing he didn't have the ability to arrest her for reckless driving or DUI.
All right. So anything else, Mr. Joe?
That's all, Your Honor.
Thank you, sir. Ms. Waldron?
With regard to the defense counsel's argument about articulable description, I believe that you did hear that today. Your Honor, this was a traffic stop where the officer observed the defendant not only speeding, as he indicated through his testimony, that he paced her vehicle going 120 miles per hour in a 55 mile per hour zone, a construction zone, no less. But he also saw her vehicle weave several times. Specifically, he stated that he saw the vehicle jerk from the far right lane to the far left lane, so over the span of the highway. And he also testified that she almost hit a construction vehicle. Your Honor, so these were observed traffic violations. They clearly rise to the level of reasonable articulable suspicion to stop the vehicle, which he did. Your Honor, in addition to that, with regard to probable cause, it was not just the fact that she refused that caused the officer to arrest her for DUI. It was a combination and a totality of several different factors and circumstances. First, it was her driving, which I just indicated to the court. She was going 120 miles per hour in a 55 mile per hour zone, a construction zone. She was weaving in and out of her lane, and she almost hit a construction barrel. In addition to that, when he first approached her, he could smell the odor of alcohol coming from both the vehicle as well as her breath. He actually asked her to exit the car to isolate her from the smell coming from within the car and further confirm that it was coming from her breath. He did observe bloodshot, watery eyes. He stated that the odor that was coming from the defendant was strong. She did admit not only to going 100 miles per hour, but she admitted to having had a beer just 30 minutes prior to driving, Your Honor. And so it was, I asked the officer in explaining his response to defense counsel, was it just, one thing that caused you to arrest the defendant for DUI? And he indicated, no, it was a combination of all of those things. And those things certainly do rise to the level of probable cause, which only requires that the officer believe that it is likely than not that the defendant is under the influence of alcohol and less safe to drive. I asked the officer specifically whether or not it was his opinion, based on his experience in performing DUI investigation and observing drivers under the influence of alcohol in his capacity as a Sandy Springs police officer, whether or not it was his opinion that the defendant was less safe to drive. And he indicated that it was. Your Honor, with respect to implied consent, and Your Honor, I'm sorry, let me go back because he did indicate that he observed the defendant also stumble towards the back of the car. That particular manifestation, we did not see on camera, but the officer observed it because they were both walking to the back of the car together. With respect to implied consent, Judge Elliott, is very clear. It only applies to breath. You heard very clearly on the body cam that when the officer read implied consent, he specifically asked the defendant for a blood test. Elliott does not apply, and therefore the refusal is admissible and able to be used against her at trial. And so we would ask that it be admissible, that the refusal of the blood test be admissible, and we would ask that you deny defense's motion to suppress based on a lack of probable cause and articulable suspicion for the stop.
The motion to suppress is denied. This is a probable cause determination, and it's not the level of beyond a reasonable doubt. If I just took the testimony of Officer Burt in pieces, and disregarded everything else but the question that Council Cho asked Officer Burt. Yes, I would agree with you, sir, that in and of itself, if just based on a mere refusal and then to have arrested her for DUI in and of itself, that would have been insufficient. But in the totality of circumstances, the admission of the drinking of alcohol, the reckless driving in terms of the manner of driving, the high rate of driving, almost hitting a construction barrel, the acceleration of the vehicle, and her own admission of violation of the Georgia super speeder laws. These totality raised the question as to whether Ms. Chris was in fact intoxicated to the level that she was a less safe driver. It's a question for a trial of fact, not a question determinative at a motion to suppress hearing. So the motion is denied. I am going to grant the defense's request to redact the video from the time that she, on the portion where she refused the field sobriety test and on the portion where she, just that part,
The portion where she refused
the field sobriety
Like,
test.
but not the implied consent.
No,
Yes, ma'am.
the implied consent is a pivotal part of the law regarding a DUI arrest and the fact that she refused to take the state designated blood test request. That is part of the entire body of the DUI statute, where the officer is required to read to the defendant the Georgia implied consent notice, and thereby the response of the defendant is part of the record and part of the case in chief.
Thank you, Your Honor.
And Your Honor, just for clarification, can I get what it is that you are granting the redaction on so that I know where to stop?
Where the officer asked her, are you refusing to take the field sobriety test, including the HGN, the walk and turn, the one leg stand, and whatever acrobatic feats are required in the field sobriety test, that portion.
Okay.
That concludes this hearing. This case will be scheduled for a jury trial. A case management order will be issued, and Mr. Toe, we have your information on file.
Yes.
So you should get notices, hopefully no more hiccups in terms of notices. When the case is called for trial, your client will be required to appear in person.
She'll be here, Your Honor.
All right.
Thank you, Your Honor. May I be
Thank you.
excused?
Yes, Mr.
Good
Toe.
day.
Have a good day.
May Miss Chris be excused as well?
Beg your pardon.
May Miss Chris be excused as well?
Yes, yeah. Ms. Chris, feel free to go. Thank you.
One moment, counsel.
Mr. Toe, before you go, Ms. Bolton has a question. Ms. Waldrop, you already have a proposed order drafted?
I don't, Your Honor, but I can get that for the court.
All right, thank you. All right, moving on, we have State versus Javon Bryant. Mr. Gaither?
Yes, Judge, we have a negotiated plea ready to present to the court.
Loitering and prowling, driving while license suspended, revoked. Are we moving on forward with both charges?
Yes, we are, Your Honor.
Okay. All right, this is State versus Javon Bryant. That's JAHBON.
Yes, ma'am.
Okay, well, on that note, all right. This is case number 21 CR 001-798E on the Orca C motion calendar. Mr. Bryant was accused of loitering, impounding, and driving with license suspended or revoked. Mr. Bryant is present with his attorney, Mr. Frank Gaither. Mr. Bryant, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you.
Yes, ma'am.
You have a right to an attorney, and Mr. Gaither will be representing you.
Yes, ma'am.
This is going to be a negotiated plea hearing. So Ms. McCutcheon, who represents the prosecution, the prosecutor's office, is going to articulate or tell me what is the recommended sentence if you decide to plead guilty to these charges. May I place you under oath?
Yes, ma'am.
You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you. Ms. McCutcheon?
Yes, Your Honor. The state would expect the evidence to show that this case proceeded to trial on the alleged incident dated April the 11th of 2021 at the location of Buffington Road and Naturally Fresh Boulevard in Fulton County. Various law enforcement agencies were involved in a special detail based on information through their investigation of street racing that was going to take place at that location. It was about 1 o'clock in the morning. Officers arrived at the location, saw crowds of persons assembled there at 1 a.m. at the where businesses at that location were closed, and those persons suspected to be in that location for the purpose of illegal street racing. This defendant was one of the persons driving a vehicle that was at that location at that time of the morning. Officers encountered him as persons tried to flee when the officers tried to detain persons to investigate further. Upon encountering this defendant, officers determined that his driver's license privilege had been suspended as of the time of this incident, so therefore he was not authorized to drive, nor was there any lawful reason for him to be at that location. On a recommendation to the court for a plea of guilty, the defendant is not eligible for a NOLO plea. I've already verified he's pled NOLO to a speeding within the past 5 years. On a plea of guilty to both charges, state recommends a concurrent sentence of 12 months to serve 3 days, credit for the 3 days that he previously served at the time of his arrest, that he pay a fine in the amount of $500, which is mandatory for a first-time suspended license conviction, and that once the fine is paid in full, that his probation be suspended.
Okay. Mr. Gaither, does your client accept these terms?
Yes, he does accept these terms, Your Honor. I'd just like to speak on his behalf very briefly. He's 24 years old. He graduated from Jonesboro High School. He lives with his parents, and he currently works as a forklift operator. And the reason, just so you know who he is, but then the reason I'm asking, I would like to ask the court to pay the court's indulgence to waive probation supervision fees because he has to pay the fine and the surcharges, and he's in the process of clearing up his license. And the Department of Driver Services, is going to suspend his license because of this charge, and so that's going to be more money added on. And then for him to get around, he's already going to have to do ride sharing and everything else. We're just asking if the court could just waive the probation supervision fee so he can pay off the fine and surcharges and clear up his license.
Okay.
Your Honor, no, counsel had inquired about the surcharges and the recommendation.
Yes, yeah, what is the total?
Associated court costs.
Repeat. I'm sorry.
Thank you for reminding me. My client just wants to know what's going to be the total, because we know it's a $500 fine, but once he adds up the court costs and surcharges, what is the total, so he'll know in his own accounting how to handle his business.
$737.50.
Thank you.
The state was close. We both agreed about $700.
That's right.
So that-
All right. And Mr. Gaither, do you stipulate the factual basis, venue, and ID?
Yes, Judge.
Mr. Bryan, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And you've gone over the list of the rights that you have to give up and so forth. Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
All right. You're very young, and losing your license at this stage is going to be a huge burden, especially on your ability to just get up in the morning and deal with life. But at the end of the day, driving is a privilege. It's not an entitlement. No matter how much my kids try to persuade me otherwise, it is an entitlement. It's not an entitlement. It's a privilege. All right. A privilege that's easily taken away and very expensive to reinstate. And you're going through that process right now. The other process that you will not be going through is a trial. If you decide to take this plea, you would have to give up your right to a trial, which includes the right to have the assistance of counsel, to go back to court, to confront your accuser, as well as examine witnesses with the assistance of counsel to challenge the evidence that will be brought against you, to also argue any defenses that you choose to present, and have the state try to prove the charges against beyond a reasonable doubt, because you have no burden of proof. It's the prosecution's burden to prove the charges against you. Now, if you want to give up these rights and plead guilty, you must let me know. Is that what you want to do?
Yes, ma'am.
And also you understand that you will have no right to appeal this sentence today that I will impose today.
Yes, ma'am.
How do you plead to one count of loitering and prowling and driving while license suspended or revoked on April 11th, 2021?
Guilty.
On the loitering and prowling, your sentence is 12 months to serve 3 days, credit for time served 3 days, balance suspended. On the driving while license suspended, your sentence is 12 months to serve 3 days, credit for time served 3 days, to be placed on probation to pay the $500 fine plus court costs that you know is now $737 in total. I'm going to waive your probation fees for the first 3 months, which will be and through the end of June.
Okay.
All right. By the end of June, if you've paid off your probation fees, your probation will be non-reporting. Understood?
Yes, ma'am.
All right. However, if you haven't paid it off and we go into July, you'll need to start paying probation fees as well.
Yes, ma'am.
Okay. Anything else, Mr. Gaither?
Nothing as far as the case, just procedurally, does he need to speak with the probation or report to probation?
He will be reporting to probation and Ms. Bolton will give him the information.
Okay. Thanks.
And he needs to report to probation next Thursday before 3 p.m.
Okay.
at 132 Mitchell Street in Atlanta. Do we have that list of paper that we give to probation? Yes. Okay. That's the form that you have to fill out. We can make a copy of it and give that to you, and you can write down the address and the date and time you have to report. Either one. All right, Mr. Bryant, do you have any other questions?
No, ma'am.
All right, thank you. Here, cover sheet, did I? Oh, yes, yes. Here we go, Brandy. Is that your okay? Yeah. So just to go over the Orca C calendar, motions, position 1, Javon Bryan was a plea. Position 2, the motion to suppress was denied. Case is scheduled for a jury trial. Bench trial scheduled at 1:30 p.m. today, and Amber Anderton and Ernest Wiggles are both null prost. So that concludes the calendar for today. Thank you.